Welcome to the Disability Granted channel. You suffer a severe disabling condition. You have no job, little income if any, inadequate health care at best. You got bills, and more bills, maybe less friends, and not much more. You need Social Security disability. You need monthly support and medical care. But you hear naysayers. Yeah, they warn you don't have any chance of winning. It's untrue. Some say you'll have to fill out hundreds of forms. That's untrue. Some say Social Security sends spies and private investigators to secretly film you, and that they try to interview your neighbors, and they try to enter your home to search for proof that you're not disabled. It's ridiculous. On this channel, I'm going to review such an article from a disability law firm's website. You might think I'm making this stuff up. Social Security statistics show that 92.5% of those who did not quit during the first 3 stages of the process were granted Social Security disability benefits. Of those who quit, 100% were denied. The message is, don't quit. You need Social Security disability. You want to know what's involved, beginning with an overview of the process. The process begins with your application for Social Security benefits. You can apply online. There's a link below. You can apply by telephone or by hard documents, the old-fashioned way. You can apply by appointment. Choose whichever method of applying is most comfortable for you. This is important. Make your best application. This is your first chance to win. It's your first chance to win disability benefits and to win them now. Answer each question, each and every question, even if they don't make sense to you, like the ridiculous questions about spouses and ex-spouses and children, stepchildren, parents and grandparents. They have nothing to do with disability. No, they don't. However, there are good reasons for those questions which can benefit you. Answer them. Might make a big difference in your case. Social Security asks you to provide your medical record when you apply. They ask you to do it. You may not have seen it, or you may have thought it insignificant. You assume that Social Security is going to have people investigate your disability and they're going to get all your medical records. How are they going to do that? They're confidential. Why do you think that they send you an authorization to disclose information? They do that so that they can get those sorts of records. I wouldn't rely on them to do it. And they ask you to provide your medical record when you apply. Who has full access to your medical records? You do? Yeah. And you know, today's medical records, they're much easier to access than before. Most of these hospitals and clinics use programs such as Epic, and it has all of your records, and they're all categorized. You could search it. If you want to search for a test, you go down to tests, and there it is. And you look and find out who ordered the test, what the test was for, the results. They're a lot easier now than they were even 5 years ago. A lot easier than having to review thousands of pages of medical records. Attorney will find things that doctors missed. Don't rely on disability services to acquire medical information which you need to prove that you are disabled. Don't rely on them. They're busy. They got a work demand. They got people looking over their shoulders. They got their own problems. Trust yourself. You can do it. One of the most common reasons for your application being denied is lack of medical records. And I don't know how many people I know that when they get their denied claim, their notice of disapproved claim, and they look at the notice and go down it, and they tell you. DSS tells you what medical records that they considered. I don't know how many, maybe all of those who are denied, they look at that and they say, well, they don't have my medical records. They don't have all these important medical records of these hospitals, these clinics, these doctors, the ones that diagnosed the disabling condition and treated it, the ones that had tests for it and all of that. Well, why do you think they were denied? Maybe they didn't even have those records, and they did ask you for them. So make sure that they have all of your important medical records that you need to prove your disability. Complete all the forms that they give you, including the application. You'd be surprised how many applications are returned with incompleted answers. You would be surprised. Oftentimes those will even get technically denied because they would be ineligible. So please make sure you answer all the questions. Remember, you're trying to prove your disability. By answering these questions, you're offering proof of your disability. And you have to look at it that way. Use the application to prove your disability. That application, your application, is first reviewed at the local Social Security field office. They don't determine disability. They review applications for technical requirements such as citizenship and residency, whether an application is a refile. You'd be surprised how many people appeal by just filing a new application, or how many people will just file a number of applications because they think the more applications they file, the better their chance is of getting one granted. They just get tossed away. The field office goes through all that. Maybe the applicant has insufficient work credits. Applications which are not rejected for technical insufficiencies are sent to Disability Determination Services. They are the ones that determine whether or not you're disabled for purposes of Social Security. A disability examiner is going to determine whether you're disabled based upon provided what? Provided what? What are they going to use to determine disability? Your medical information and your vocational information. Cooperate with your disability examiner. Be patient, be polite, be considerate, complete forms they require. There aren't that many. And complete them. Don't just rush through it and scribble on them. And I'm going to go through forms on this channel, and I'm going to show you all how you can answer these questions. You have to remember, every answer is intended to prove you're disabled. Every answer. Make it easy for your disability examiner to evaluate your case. and understand that you are disabled. You know, it may take 3 to 6 months for them to decide your application, maybe longer. Traditional authorities say only 30% of applications are granted. You'll see that on attorneys' sites and other sites. Only 30% of Social Security applications are approved. To get that number so low, they must include technical denials by the field office that have nothing to do with disability determinations. They have to use rejected applications that were rejected for technical eligibility reasons. What do Social Security statistics tell us? They're available. There's a link below. You could go to Table 3 and you can see them for yourself. Social Securities indicate that 64.3% of beneficiaries who applied only for Social Security disability were approved at the application level. 64.3%. That figure was in 2019. I use 2019 for most statistics right now because they're the most recent at the time I'm producing the video. 369,929 applications were approved. Yeah, every one of them got benefits, and they got them now. That's what you need. You want to be one of them. If your application is denied, they'll send you will receive a notice of disapproved claim. What's the first thing you're going to do with it? Anybody think about it? What's the first thing that someone that gets a notice of disapproved claim that needs disability benefits, what are they going to do with that notice of disapproved claim? They're going to toss it in the trash. Almost every time. Do not throw it away. Don't. Use that notice of disapproved claim as a blueprint for winning at the reconsideration level. That's the next stage of the process. The notice of disapproved claim states, among other things, what medical records were considered, as we were talking about, and they do so to determine whether DDS failed to consider important medical or vocational records. Or maybe they just made a mistake. Maybe you didn't provide them all the medical records. Maybe they didn't obtain them and you didn't provide them. Happens a lot. But you know what? If you provide them, they got to use them. So get your medical records. Get them. Provide them to Disability Determination Services. Request for reconsideration. That's the next step. That's the second step. You're appealing the denied claim by requesting reconsideration. Your notice of disapproved claim should have attached forms with it when you receive it. And you'll receive the request for reconsideration form. It's not very long. It's rather short. In that form, they do ask you the reason for requesting reconsideration. Most people don't know why that's there, and they really don't know what reason to put down there. All right, let me answer that. They ask that question to determine whether your reconsideration should be handled as a medical or a non-medical appeal. However, you can use that question as an opportunity to identify important, missing, or incorrect medical or vocational records. Reason for requesting reconsideration: you did not include the record of Dr. So-and-so which diagnosed my disabling condition above blah, blah, blah on such and such date. That's a good one. Wakes them up, doesn't it? Lets them know right off the bat. Traditional authorities, those are the same ones that had all that other nonsense. Remember we talked about at the beginning? The traditional authorities suggest reconsideration is a waste of time. They ask, hey, why would disability determination services say that you're disabled after they just said that you're not disabled? They say, reconsideration, I've heard lawyers say this. They say reconsideration is little more than a speed bump on the way to an administrative law hearing, the great mecca of Social Security law. All right. Requesting a hearing, that's the third level in the process. But let's get back to reconsideration. My experience is that reconsideration is not a speed bump. It's an excellent opportunity to win. Really, in that notice of disapproved claim, they gave you a blueprint on how to win. If you win at reconsideration, you get benefits. And guess what? You get them now. You won't have to wait 10 months to 2 years or maybe longer for a hearing. In 2019, 37,200 people were granted disability at the reconsideration level. You know what? They got their benefits and they got them now. They didn't have to wait for a hearing. You want to be one of them. If your application is denied, you want to be one of them. Now, people don't talk about it, especially traditional authorities. Maybe they don't even know. But we didn't always have a reconsideration level. We used to just go, somebody has their application denied and request a hearing. And you'd have a hearing without waiting 10 months to over 2 years. Those days are long gone. One reason for the reconsideration level is to ensure that all material information was used to review your application. And if it wasn't, this is an opportunity to apply all the information. Everybody agrees it's all the information. You provided it. They've looked into it. They've gathered information. You've gathered information. Among other things, reconsideration allows DDS an opportunity to consider information it didn't have or information it had wrong. That's why we have it. You get a favorable reconsideration, there's no hearing. Reconsideration weeds out all those cases that shouldn't have to go to a hearing. That's the way it would work if it was used properly, not as a speed bump. Now, if you don't win at the reconsideration level, that's called an unfavorable reconsideration. If you received an unfavorable reconsideration and you quit without requesting a hearing before an administrative law judge, you lose. No benefits. You just wasted your time. If you quit, you lose. You still have another level available to you. You're afforded 3 chances to win. At the application level, at the reconsideration level, and at the hearing level. You have 3 different chances to win. Don't ignore any of them. The remainder of those people requested hearing before an administrative law judge. Those that didn't quit requested a hearing before an administrative law judge. And that's the third step and the third chance of winning Social Security disability. The long pilgrimage to a hearing before an administrative law judge begins. 10 months to 2 years, and maybe longer, waiting for a hearing. And you need benefits, and you need them now. But if you quit, you'll never get them. Traditional sources, they just know everything, don't they? They often tell us that your chance of winning a hearing before an administrative law judge is 45 to 50%. However, as reported by Social Security in Outcomes for Applications for Disability Benefits, Table 63, that's medical decisions at the hearing level or above, which would be the appeals council, maybe even federal district court. Up to 64.3% of Social Security beneficiaries, not including SSI. SSI has resource and income limitations, other limitations that Social Security disability SSDI does not have. 64.3% of Social Security beneficiaries, not including SSI, were granted in 2019. That's a lot. Now, if you include SSI cases with their eligibility requirements, which go far beyond being disabled people cannot get SSI unless they meet poverty requirements. And these requirements are extreme. Some of them haven't been adjusted for cost of living in 34 years. That's the subject of another video. But including SSI cases, the average who won their hearings was 48.1%. I guess the naysayers could say, hey, I told you so. No, they didn't tell us that because you're concerned about whether a disability claim is going to be granted. And some SSI claims don't even determine disability. SSI can be for people aged 65 and older who are impoverished, among others. Whether 45 to 50% win or 64.3% win at the hearing level, you want to be one of them. However, according to Social Security, once you've requested a hearing, as I said, you've got to wait 10 months to 2 years or longer. But Social Security says there are things you can do to expedite your hearing, which are discussed in another disability granted video. And there are things which you can do yourself to expedite the hearing. Now, before the hearing, you may be able to win. You may be able to win without the hearing that you've requested. You may be able to win with an on-record review. You can request an on-record review. And that's asking the Office of Hearing Operations, it's asking them to review the records and determine whether or not you, as a matter of law, are disabled. In many instances, they are. You could be granted disability without a hearing. Most of these requests for on-the-record review, they're little more than a very well-written letter. Attorneys can put down all the pertinent facts, lay them out so that the people who determine it, and this is a special group of disability determiners that do on-the-record review. It allows them to focus on what to look for. If you're granted disability with your on-the-record review, you don't have to wait for a hearing. Guess what? You get disability benefits, and you get them now. You may be surprised to learn that your hearing, remember this hearing? Yeah, the great mecca of Social Security disability law. hearing before an administrative law judge? You want to know what it is? It's going to surprise you to learn that your hearing won't be in a grand courtroom, and you might have expected a government lawyer to be there to challenge your claims and do a blistering cross-examination of your testimony, and you may expect that your family and friends, former employers and co-workers, and your doctors are all going to be there to testify. You may envision dozens of pews in the courtroom with press members and excited onlookers. Nope, not happening. Your hearing will be in a small room, or it will be done by a video conference, maybe even by telephone. There's no government lawyer. Often, no witnesses testify. The most often testimony from a witness comes from a vocational expert, and your doctor isn't there to testify. It's just you. It's just you and your representative, an administrative law judge, court reporter, and often a vocational expert. The courtroom, it may be the size of your living room. Now, the judge may allow testimony of a family member or friend who's familiar with your disabling condition. He doesn't have to. The testimony of your witnesses is provided to the court in written third-party function reports. They don't testify. Their testimony is in writing, and it's presented before the hearing. The judge can review that before the hearing. That may be an advantage. Otherwise, he hears it for the first time in the hearing. Your treating physician testifies through his medical records and perhaps a residual functioning capacity report. You will not find that form, the residual functioning capacity report. You will not find that with other Social Security forms online. You have to request it. That form is used by administrative law judges on occasion where they want the applicant's treating physician to complete that form. But I'll tell you one thing, a lot of treating physicians do not want to complete that form. They're afraid that they may answer incorrectly, or they may answer in a way that it costs you Social Security disability. They don't want to be blamed for that. His Honor hears your testimony, perhaps testimony of a vocational expert, arguments of counsel, and reviews the evidence before making a decision. Guess who tells us that? Social Security. If that decision is unfavorable, and you won't know it for a few weeks, you're not going to get a decision right there in the courtroom. It's not going to come for 2-3 weeks or longer, favorable or unfavorable. If that decision is unfavorable, you can appeal His Honor's ruling by requesting review of his decision by the Appeals Counsel. That's the fourth level of the process. The counsel will not rehear your case. Generally, the Appeals Counsel reviews his or her Honor's decision for errors of law. And believe me, in Social Security law, I don't care if they're administrative law judges and they do it every day, Social Security law can be tricky. The Appeals Counsel reviews his or her Honor's decision for errors of law, and it can reverse and remand His Honor's decision. It can reverse it and send your case back for rehearing, a new hearing. That puts your case back in the hearing level and another chance to win. And frequently, in some instances, the appeals counsel may even reverse His Honor's decision and enter a favorable award in your favor. That's not very often. If the appeals counsel affirms His Honor's unfavorable decision, you can appeal that decision by filing a lawsuit against the Commissioner of Social Security Administration in federal district court. That's the 5th level of the process. A federal district court judge may affirm, reverse, remand, even modify, or enter an entirely different decision in your favor. Can do it. So those are the 5 different levels of the Social Security disability process. It's an overview of that process. If you believe this video can benefit other disabled persons, please share, like, and subscribe so they may watch it. Thank you for watching the Disability Granted channel, and good luck.